Hello, my name is Kieran Afzal, and I am a trainee solicitor for Bodge, Dodge and Hassel Solicitors. I am also a trained mediator for the purposes that we have gathered here today. Miss Esmeralda Ewax, I will firstly be taking yourself through the process of mediation and how it is that it works, after which I will be explaining to you the advantages of taking up mediation, and in particular the advantage that you and the other party could have if they result to mediation in this particular situation. So firstly, I will take you through the process of mediation. We begin with the opening phase, within which I would have a joint meeting with both parties, within which I would introduce myself and set out any rules that would be in place to allow a fair mediation process to go ahead. Rules such as the fact that mediation is confidential and anything that is said within the meetings cannot be used should a settlement not be agreed to outside of that mediation process. Mediation is also a voluntary process, and both parties can terminate the process at any time. Another example of this rule is that there can be no interruptions when one party is speaking, and parties are encouraged to take notes of any matters that they want to later discuss. The second phase is the exploration phase, where I would have private meetings with both parties, allowing them to present the case to myself. The next stage is the negotiation phase, where I would facilitate both parties to try and come up with a solution and put forward proposals that could, in the next stage, which is the closing phase, come to an outcome or a settlement, and hopefully reach some sort of agreement, as it were, to the problems at hand. The advantages of mediation are that the two parties are in control. In this situation, you don't have a judge providing a judgment and imposing something upon them. The parties are the deciding people. It's speedy and cost effective. In fact, as in the case of Stewart against Gallop and Gallop in 2010, it was stated that costs of proceedings are usually disproportionate to the value of the land at stake. And in particular, one particular advantage that would be adhered to, as in your case, Miss Ewax, is as in the case of Pennock v Hedgeson 2010, where Lord Justice Mummery stated that litigation always costs a lot more money than it is worth, and it usually creates a lot of ill feeling that isn't good between neighbours. As I understand, you had a previous good relationship with your neighbour, and I, as you would agree, that it is having ill feeling between neighbours is something that you would want to address and not let linger on, where litigation would not solve such a matter. That concludes why I encourage you, Miss Ewax, to take up mediation as a process to solving the problems that you currently have with Mr. Skydiver. I will now move on to scenario 2, presuming that both parties have now taken up mediation. I will now take Miss Ewax through the draft settlement as drafted. Miss Ewax, we have been through the process of mediation. I have, as your mediator, come up with a draft settlement that has been drafted and sets out the legal and non-legal disputes that you both as parties have at hand. In order to solve these, we have come up with possible resolutions that have been proposed. Now, these are firstly that Mr. Skydiver would turn down his music and close the window in order to stop your dog from barking. Secondly, you would ensure that relatives and friends of yours, when they come to visit, would not park across Mr. Skydiver's driveway in order to stop him from being able to reverse his car out. Thirdly, Mr. Skydiver would ensure that he disposed correctly of his takeaway boxes, so that no foul smell could be smelt by you. Fourth would be that you would ensure that your dog is properly trained and does not excrement on your neighbour's property. Finally is, of course, the major legal dispute of the boundary, which Mr. Skydiver has wished to erect a fence between your two driveways. As we understand, you have the concerns that this will narrow your driveway and you will not be able to get out of your car due to your bad back. The proposal here is that Mr. Skydiver is allowed to erect a fence, but in between the two boundaries that you to argue is the correct boundary, as it hasn't been established by the title deed what the correct boundary is. We would suggest that Mr. Skydiver is able to put the fence in between the red and blue boundary lines as marked. That would so allow you to get out of your car with ease, while still allowing Mr. Skydiver the privacy that he requires. Miss Earwax, I would encourage you strongly that as Mr. Skydiver has signed the draft agreement, that you should also sign this agreement and allow this situation to be resolved, as the proposals are a good compromise. They're fair and not biased in any way. Of course, not everyone can win in the situation, but the best way forward is to reach a compromise. The proposals here are solving all the issues at hand, and you're stopping yourself from going into litigation, saving on money and time and dealing with the issues at hand. This was also likely to stop any ill feeling that two parties might have, and hopefully go on to reconcile the relationship that you once had. For that reason, Miss Earwax, I would strongly encourage you to sign the draft mediation agreement and to allow these issues to be solved. Thank you, Miss Earwax.